Aileen Armstrong. I'm Executive Director of Strategy, Innovation and External Affairs at the SRA. Our first session with panellists this morning is about choosing and using AI and tech in a law firm. And really, this follows on very much from the report that we just heard about and some of the issues that were raised in that. And as I said, today we really want to get into some of the practical insights and the ways legal firms are already using technology and AI. And, maybe this will spark some ideas, that are available now that might be of use to you in your day-to-day work. The panelists have a really broad range of experience between them. I'm going to introduce them super briefly in a moment because I could have chosen any number of job titles for many of these people. So I will open up the conversation when we're talking and give you all a chance to say a little bit more about your backgrounds and what's relevant to the event this morning. But I'm hoping that we're going to be able to really explore, what our panelists have seen personally or heard about in terms of what and how tech is changing the legal sector. And, as I say, and we've asked in advance, to be thinking about any kind of really accessible, kind of quick wins, I think is going to be really useful to help people understand, if there are things that they can do to embrace technology. And particularly if you're sat there thinking, I want to be able to do this, but I don't know where to start. I think you're absolutely in the right place. So let's welcome our panel. Starting over on your right, we have Harry Borovic, who is General Counsel at Luminance. Then we have Alan Marr, who is Chair of the Legal Tech Committee at Birmingham Law Society. And next to him, we have Paddy Skinner, who's General Counsel at Atticus. And by me is Paul Saunders, who's Managing Director of Legal Eye. I'm going to start with a question, actually, the same question to each of our panel members to enable us to really get to know you all. And so the question is really about what part technology is playing in your job at the moment and how has it changed it for the better? Can I kick off with you, Harry?
First of all, it's great to be back in Birmingham. I went to University of Birmingham, so it's great to be back. I haven't actually been here since I graduated 16 years ago, so it's great to be back. Not quite sure what took me so long. I'm in an odd position, which is I work at a legal technology company, but I'm also the general counsel there. So I think we spent, very high six figures last year on legal fees, fundraising, all the rest, right? And Luminance itself, incredibly useful for lots of contractual workflows, that's what we do, but loads of my workflows are non-contractual. And where I've seen the greatest ROI outside of our own product functionality is how I interact with external counsel. So 3-4 years ago, Luminance's business was about 70% law firms. Now it's about 20 to 30% law firms. That's not because the pace of growth amongst law firms has declined, it's that in-house adoption has just been massively faster. The reason for that is in-house teams expect more of their external counsel, they want fees to be lower, they try and see how they can cut costs. We're no different, right? So if you want to provide an advantage as an in-house provider to your team, or you're an external counsel who wants to deliver services rapidly, it's about seeing how you can trim fat, reduce margins. The simplest thing is I never ask external counsel for advice without first having done my own research. Now, what that research is looks completely different than how it did 5 years ago, where it might be a skim through PLC. The ability to ask a well-cited, professional-grade, low-cost search system like Perplexity or a Claude system where you're paying, £20 a month, inexpensive and accessible. I can verify every source. I'll ask it to provide a piece of legal advice, send it to external counsel, say, don't draft it from scratch. I've got this. Point out what's wrong, add what's extra. I've just cut my legal bill by about 60, 70%. And if they try and charge me something similar, I say, you didn't write this from scratch. I'm asking you to read something and give me your thoughts on it. That's the big difference in the dynamic shift. And it's been hugely saving from our cost perspective. We actually grew massively, but cut our legal fees just by mandating that across our law firm approach for external advice, particularly when growing internationally. And I appreciate on a regional basis that might be different, but you may well be advising businesses scaling internationally. It's a sound approach for when you're consolidating that advice. So the first pass through AI is a game changer as an in-house counsel.
Thank you, that's great. Alan, I come to you with the same question about the part technology is playing in your role at the moment.
Yes, I'm qualified in law, IT, and engineering, and I practiced law more than 20 years before I became an academic. And now I'm teaching at Birmingham City University, and the answer to your questions is that, yes, technology is central to both parts of my work. Now, at Birmingham City University, I instigate and launch a final year module in legal tech. And the key of the module is student is not just studying legal tech, but they use it. So we provide their real-life hand-on experience so they could try to use the packages in practice. For example, case management package system, as well as the AI-assisted contract review. So that's the first element. As I say, I'm going to let them to use it and give them to more than that. It's come to my second point of hackathon. I use hackathon as a teaching and learning mechanism so that the students work in teams and they work with each other and they try to deliver a solution of the challenges within a tight time constraint. But I also got a third point. It is not only teaching them how to use it, give them experience how to use it, but they also have the opportunity to explore the use of AI so that they could have an understanding how to engage the technology critically. They have to think about critical use of AI so that they could, in future, because we try to develop future lawyer, in future, they could enter the industry responsibly and also think about the ethical side and use it intellectually. So that is my legal education side. I'm moving to the next side, next part of my life, which is the chair of legal tech committee at Birmingham Law Society. Now, I engage with practitioner and the profession, and we relaunched. In fact, we used to have a legal tech committee, but it stopped for whatever reason. But we relaunched it earlier this year because of the growing importance of using technology in legal practice. So in here, we create a collaborative network of lawyers, academics, as well as legal tech provider. And what we're going to do in here, in our committee, we exchange information, we share insights, we try to remove barriers to adoption, and we promote innovation. I see technology give the opportunity for legal education and legal practice all evolve at the same time. And I see myself in this role. I give me opportunity to ensure students, they are studying what the industry need as well as the law firms can see what they benefit from the development in the legal education.
Yeah, that's
what I want to say.
great. Yeah, thank you, and great to hear about kind of the two angles. I think. Thank you, Paddy. I'll come to you about really the change you're seeing. If you could talk to us a little bit about that in your role.
Absolutely. So rather like Harry, I work for a tech company. So in that sense, technology is pretty foundational to my career. I use technology actually not in that dissimilar a way to Harry. So our tech platform is designed to fact check information. And so we have two buckets of clients. They are law firms who use us on a range of different matters, from sort of capital markets, on the dispute resolution side, to check information in expert reports, pleadings, etc. Private equity, looking at the sort of placement memoranda and so forth. And I use the product, but in terms of the technology that I use on a day-to-day basis in my role as General Counsel is primarily to reduce some of what I guess you could describe as the grunt work. And so I use Gen AI as, I guess, a highly efficient but somewhat flawed paralegal is the way that I would probably describe it. And so an example of which would be reviewing pretty consistent supply agreements or employment contracts that I have to review on a pretty regular basis, and having pre-built prompts that point the technology in a direction to give it a kind of a first pass review. I can then use that information to either enhance the advice I'm giving or to pass it on to counsel. The other sort of thing that I would raise is that I also use it quite often in a kind of cultural way, in that, well, lawyers, we've been in that situation where you get a pretty sort of heavy-handed email at sort of 6 p.m. on a Friday, and your immediate response is to type back something probably slightly overly aggressive. And so, and that can be, a message from the other side. It could be like a demanding message from one of your colleagues, perhaps. And so I might jot down that message, and instead of sort of like deleting it from my notes, ask a Gen AI system to maybe tone it down a bit, which sounds like a pretty basic thing, but actually is quite a good sort of quality control check to maintain morale within the office, if nothing else. And so, yeah, they're the key ways in which I use it. And again, if I go back to my time as a lawyer at HSF, I had none of this at my disposal. And actually, in some ways, there were senior lawyers, and this is not just at HSF, I heard this across the board, that would almost actively discourage technology for that kind of grunt work. Because, I did it this way when I was training, when I was a junior, and this is a really important way to learn. I think there is some truth in that, but ultimately, if you say, it could be due diligence, it could be e-discovery, it could be verification, it's probably useful to do a bit of it, because you want to know what a termination provision looks like or a change of control clause. You want to be able to find the smoking gun. But doing it 1,000 times a day, I'm not entirely convinced is good for your career development. And that kind of, again, sort of more a cultural change has happened quite a lot, particularly over the last sort of 3 to 5 years.
Thank you. Really interesting, and I've scribbled down one of my first takeaways for the day. I'll let you think about which one that would have been. And Paul, just wanted to come to you finally, just on this opener. Tell us a little bit about what you're seeing, and particularly that focus on things that tech has enabled you to change for the better.
Yeah. Good morning. I'm clearly the odd one out on the panel. It's really fascinating to listen to general counsels from organisations and their expectation level of us. So Legal Eye is an outsourced risk and compliance function that's used by lots of organisations, and we see a huge amount of tech being utilised and a huge amount of conversation around AI and expectation of it and what it may or may not be able to do for us. But interestingly, for us, we're part of the PEXA Corporation internationally, which is a tech-based organisation. For my sins, I am the culp of Optima Legal, which is a very large factory running 7,000 transactions a month. And I'm also MLRO and MD of a high street 20-person conveyancing practice. So kind of see all across the piece, hopefully representative, therefore, of all sorts of behaviours around tech and the way we utilise it and the expectations that we have as an organisation. We saw on the research, 78% of us are small organisations. So the majority of you probably in the room fit into that category. And actually the most helpful people around you are those that are actually sat next to you, potentially rather than the ones of us that are sat up here. But when you then start to hear things about their expectations that we do things cheaper, we do things faster, we do things better, I start to question, and I understand the pressures and the requirements from in-house. I was a general counsel for a period of time in an organisation. But I think we actually have to step back and start to look at technology and tell technologists what it is that we want and what it is that benefits us. We are the experts. We are the professionals. We went through a qualification process for a reason. We do want to do it better. We want to do it more efficiently. Don't like the word fast. That worries me because client is key in all of this. And it is absolutely essential they get what they want out of the experience with us. That isn't always speed. So, yes, let's get technology in place. Let's talk about what we're using. Let you talk about what you are using with your colleagues and see what's good. But don't assume the technologists know what we need.
So actually, I was going to build on, thank you very much for all those introductory comments, but I was going to build on that, and I'm going to come straight back to you, actually, Paul, to kind of build on those points. So, we saw in the research that many people, just feel, okay, there's just an array of stuff out there. Where do I start? And you've given us some food for thought there about, well, the individual is the expert, knows what they need. Can you think of and maybe talk to us about a little bit of kind of advice? Okay, so if you're in that position, where do you start? How do you do that? How do you find the right thing for you, and how do you go about engaging with people to get solutions?
Yeah, and I think the key to this is not to jump in at the deep end. I think it doesn't matter what the technology. It's interesting we talk about technology and AI as two independent things almost. Actually, technology has potentially included AI for 15 years in varying formats. Yes, since 2023, we've highlighted it, and we've had ChatGPT, and wow, we've had solutions where you can go and check information, and maybe correctly, maybe incorrectly, the advice that comes back. And yes, you can use your expertise to temper it. But I think what's absolutely key to this is that you start back at basics. And we were always taught and trained to do that. That's what our education was about. It was about looking at a problem and trying to get a solution to it. Well, our problem at the moment is how do we utilize technology in our particular business to benefit us as practitioners? And as a consequence, we therefore need to think about how do we protect the client and our own business. It's about running our businesses well and efficiently and making the most money we can. It's not about spending the most money that we can on tech, which is sometimes how it feels when technologists are selling it to us, because we very often get told, oh, it's fine, you can pass that on to the client. Well, working from a property environment, yes, you can pass it on to your client, but the consequence is you're going to reduce your legal fee because actually your fee will not take a hike up much further. So that competitive element is a huge challenge for us. But actually, make sure you've got your policies in place. Make sure you understand what the technology may or may not do for you. And make sure you've done the really boring stuff, which is things like the data impact assessment. Actually talk to the technologists and find out where their data goes. I've had a huge pushback recently in relation to some ID challenges in Optima, where we have a client who has a clause in the agreement with us, which is an old agreement, which says that data can never be processed outside of England and Wales. It's pretty restrictive. And I've had a fight with an ID provider who, when other people in the organisation were talking to them, said, yeah, that's fine. And we got the data impact assessment and sent it to them, and it came back and no, that wasn't fine. Now we'll solve for it. 6 months later, we're still trying to solve for it. And we're wanting to put 6,000 or 7,000 transactions through their platform, and they can't tell me that they can produce the data processing in the UK. Well, I could easily have signed up to that agreement, and I'd have been in breach of all sorts of things. So it was the basics that would have caught me out. And I think those are the conversations that you need to have, because there's a plethora of stuff out there, incredible stuff, and it makes massive difference to what you do. There's also an awful lot of really simple stuff that you can do right at the outset, just to get comfortable and just to see where the advantages might be for your particular business. Really good example is the readback facility. If anybody's got Copilot, the readback facility for people that are dyslexic in your organization is massive. It cuts down time incredibly and disproportionately to what you would expect if you do not have that particular disability. So really simple stuff that people will have in existing products. And I know Copilot can be expensive for a very small business, but actually a lot of you have probably got it and not necessarily using all of the functions, for example.
Thank you. Harry, I was going to come to you and ask you maybe to reflect on some of those points. And I wonder, in particular, again, from the perspective of someone who may be running a small business, solicitor running a small business, and some of those challenges, what would you say in terms of product providers being able to, lean in and help and advise and help ensure that people are able to find the right thing for them?
Yeah, at the more expensive end of the market, Luminance is mostly an enterprise-level product for large law firms and large companies. So lots of customer success and hand-holding is sort of part of the expectation. So that's normal, whereas most cheaply, readily available AI products that are open to everyone have a bit more of a figure-it-out-yourself kind of approach. What Paul said, I agreed with the final 90% of it, but these panels are always boring if everyone just agrees with each other. So I'm going to pick a slight one, which is right at the beginning, putting my general counsel's hat on, but also I teach AI ethics at King's, and one of the questions we always ask is, what do people want from lawyers? Right? Do they only care about fast? Yes. Anyone else who's saying no is deluding themselves. Do we want clear and fast? Yes. Do we want right and fast? Yes. Do we want concise and fast? Yes. Do we want applicable and fast? Yes. But fast is always better, right? There is zero circumstance where if all other measurable outcomes are even, you want slower, unless you are actively doing it to slow roll a deal. That's potentially same in litigation. But there is no circumstance where my CEO wants something from me and me doing it slower is better if the other outcomes are measurably equal, sometimes even better, right? So that is what is important. And again, law firms can take it the other way around, which is the faster they can turn things around, the more business total they can take on, the more they can diversify their risk. From my perspective, and actually I speak to lots of other GCs and GC communities, people use law firms for one of probably three reasons. One is professional indemnity insurance. They want to displace risk. Two, there's a process that we can't access ourselves, something like conveyancing in the UK. You need a solicitor to do something for you, maybe insurance for placing, all kinds of other things, or genuine expertise, right? But all of those, well, one doesn't really change with time, with pace, and the other two, if the outcomes are the same or of an equivalent, broadly equivalent quality, faster is better. Now, good vendors at the more expensive end help their customers, whether that's law firms or in-house teams, achieve measurably similar outcomes, hopefully at a greater total cost efficiency and in a faster way. That's the goal outcome, basically. But otherwise, there'd be no point in applying these tools. Faster and cheaper is the goal. Now, if you're in-house, it's to minimize your external spend whilst managing your risk, right, and getting the expertise you need. If you're external counsel, it's in order to build your total trust with your customer, take on more business, and scale, right? So I do think there is a challenge that if you are a smaller firm and you need to take on AI tools in order to remain efficient, the trust that you have to place in these tools has to be lower because you need to be more critical. And I definitely agree with what you were saying about going back to first principles of are you ticking off the basics? Because you need to be twice as critical of a tool that isn't giving you very clear assurances. One thing we have, for example, at the back of our T's and C's, we've got a long tech vendor T's and C's like every tech vendor does. And at the back, we have a plain English explanatory summary of every assurance. Yes, we have carried out a fundamental rights assessment. Your data stays in these jurisdictions only if you are based here. Like plain English, you don't need to be a lawyer to read, right? The reason for that is even our service delivery, people want it fast. Hey, I need sign off from my CFO, here's the concise summary. That is important. You don't get that with everything, and there's a balancing act to be done. You know, for example, Atticus is a great tech company, does something completely different to Luminance, but there are great actors in the legal tech space. If your need is clear to you as a business, it's normally going to be driven by one of those three factors I mentioned, and good vendors help you get there.
Thank you. Well, let's come to Paddy. I mean, maybe you want to build on that a little bit. In terms of, again, confidence, or even action is sometimes, about kind of you getting over a kind of fear of problems and pitfalls. I wonder if you could maybe give us a bit of your perspective on your experience of, okay, what do people see as kind of common pitfalls? What are the red flags that people need to avoid, and how to kind of come through that?
Yeah, well, I think there's a pretty interesting economic story in the UK whereby it is an unbelievable jurisdiction to both build and buy legal tech. It's English language, common law jurisdiction, there's access to a lot of data, and also the way that the law firm business models typically work over here is that the fixed fee cap concept is pretty prevalent. And so there is a real desire for efficiency across the board, from Magic Circle all the way down to the sort of one-man bands. And that has been a key driver for a lot of startups to be created here. However, there is like a deeper problem, the kind of like mind space problem, where you build an amazing piece of technology over here, and then it eventually gets bought by a US conglomerate. Like, that is the story of UK tech. And so that provides some interesting benefits, but also some pitfalls. And so the benefits are there is a load of really good tech here that you can access pretty early stage, which is really, really useful and interesting. But there are also a lot of sort of underlying kind of techs behind some of these startups, or that subsequently buy these startups, that are based in the US. And so everything like ChatGPT, Gemini, et cetera, it's all US. And so that's something to bear in mind when you're buying tech, because, for instance, if you're looking to review that sort of supply agreement I was referring to earlier, it's not uncommon, even if you say, I'm an English lawyer, I'm based in Birmingham, this is a contract between my company and another English entity, Americanization of the review does creep in. And that is a problem and something you need to be aware of. We all know about hallucinations. There's some pretty high-profile instances of, barristers sort of submitting pleadings with entirely hallucinated cases, and so that is always something you need to be aware of to double-check the review. For me as well, on a practical level, when you're assessing tech, whether it's a conglomerate or whether it's a two-person startup, if they don't have a sufficient number of lawyers working in their team, for me, that is a massive red flag. Every single member of my UK team, bar one, has at the very minimum a law degree. Most of them have practice. And I think it's very difficult to disseminate how technology can be applied to an academic and quite complex profession unless they have a sufficient number of people who have actually done the job or a version of the job before. And so when you're assessing tech, just to kind of highlight those points, Americanization review, hallucinations, making sure there is like a local law kind of base to the way that the product's been built, and also making sure that there is internal expertise at the vendor that you're looking to contract with.
Thank you. Before I open it up, I was going to change direction a little bit, but did anyone want to reflect on any of those points that have been made?
Just in terms of the language that we use, the accuracy and the result and the outcome far outweighs the speed and efficiency of anything that we do in our industry. Speed is a word that we bandy around quite liberally, and I think it is really important to ensure that your point, Paddy, that we are utilising the skill sets accurately and right. We use the technologies to ensure that we do the transaction in the best way possible. The natural consequence of doing that is that it becomes faster and it becomes more efficient. If a client comes to me on the basis of wanting something done fast, that is a red flag. It's not only a red flag for Legal Eye in terms of how we assess a risk profile, an urgency is always something that is concerning. So I think if, we're talking about AML, we're talking about fraud, we're talking about all sorts of things within our industry, and one of our largest flags from the regulator and from the risk professionals is be aware of speed. Now, I also know from a general counsel's point of view, having done it, that the pressures that I had internally were to get things done quickly. Actually, if you're in the property environment, you very often actually, and 78% of you who are faced with the client who says, I'm actually not moving until September because my child starts school then, and this is April, you are possessed with that information and you have a buyer who wants to move tomorrow, you have a challenge there, and speed is unimportant in that particular instance. I also then work in an environment where we completed 2,400 transactions on Wednesday and moved £1 billion worth of money in remortgage because the lender requires us to do it within 14 days. So I get both sides of that coin, and I think we just as a profession have to be the judge of it. And if the client is there requiring that, if we can utilise the technologies and the processes we have to do it, fantastic. If you can't, then raise your red flag for your organisation and ensure you don't do it.
Yeah. Great. I think a modicum of consensus arising. I was turning to you, Alan. You spoke earlier, actually, about one of the modules that you teach. And so a slightly broader question, really, about, with all of this change and the opportunities that are there, from a kind of legal education perspective, how do you think legal education can better prepare people, lawyers working, in this world into the future? How can legal education help prepare lawyers for working with AI and tech tools, and other things that you are seeing changing or that need to change in that sphere?
Yes, I think we need to do two things better. First one is how to equip students with to use tech more confidently, more comfortably. That's the first thing. But secondly, is equally important is how to develop a sense of awareness of how they use AI in future when they go into the industry, so that they look at the use of AI critically. So I embed both in my module. So the first one, how to equip students more to use AI more competently or more comfortably, is I use the practice-based hand-on experience so that they could use it. We deliver our session in a computer lab environment so that they all can have a hand-on experience with the packages used in practice. For example, I just say a case management package, as well as the AI-assisted contract review. So the first thing. The other one, I go back to my hackathon. I'm talking about a hackathon, which is a kind of teaching and learning model. So students can work together as a team, and they work together to deliver a solution for a challenge within the time frame. Now, why they need to do that? It creates a teamwork skills so that they could take it to work in future. Secondly, they also learn how to filter information. it is important. I see it as very important that they need to know what kind of information useful, what kind of, and they distinguish from misinformation. I think it is very important that they have this kind of skills to develop further in a tech environment. And in addition, within this hackathon model, they have to do some kind of independent research. So it developed their independency as well as professional judgment. So this is the things that we help our students to equip themselves for the future. And then the second part is I take it one step further. I introduce TensorFlow Playground, which is an interactive model so that a student can play around with it. It's some kind of sandbox. And why? Because they could see how a machine learns, how we change the machine, and they have a better understanding how AI works, and more importantly, how AI sometimes doesn't work. Things like hallucination and why they come up with bias result, so that students can play around with the input, play around with the parameters, and they come up with different outcomes. So I see it, there's two things. So my philosophy is that, yes, to teach them how to use it, but at the same time, they have to look at it critically. This is to develop their culture of being aware of this, how to use AI ethically and intelligently for the future. So this is how I see it.
Yeah, thank you. And I mean, one of the things, that featured in the research, and this is, I don't know if any of the panel want to kind of comment on, in the research, one of the issues was about, established lawyers working, who maybe like myself for a few years out of university, not necessarily, having all the benefit of that in their minds now. I wonder if anyone would like to comment on, actually, how does one equip oneself, if one's already practicing, to feel confident, to feel competent to use these tools? Who would like to come in? Harry?
I've currently got 2 trainees and 2 MQs who were trainees and came through as paralegals with me. And so this discussion comes up a lot. And the risk of using an AI research tool to search for something, especially if you're not putting a customer name in the search of what is a legal position of X, is an incredibly low use case. Go run wild, right? That's my approach. It's like you're not going to get berated for using what Paddy mentioned about lawyers being, that's not how I did it in my day. That doesn't fly when what you're actually after is getting to the right answers quickly and efficiently, but also developing critical analysis skills in someone's training. And I totally agree with Alan that critical analysis is actually what people really, I think lots of lawyers would like to think, of our own intelligence, that what we're good at is critically thinking through problems, and critically analysing the tools that we use is just one of those skills. So I don't actually even say use Sandbox. When you're training, by all means, especially for higher risk things, if you want to play around and see what outcomes are, especially if you're using real data to play on what Paul said before. But I'd just say, go run with whatever you want, and if you get to an answer and you use the tool, tell me why and how, and then we can critically analyze it together, because I will still in many cases be able to say, well, it's completely missed something over here, but that's no different than I would say, you've completely missed something over here, when they would have used, a book or a PLC or whatever it was 5 years ago. So the dynamic hasn't really shifted. It's that there's a greater breadth of tools available, and I think we should be actively encouraging them to do so. I also think the outcome of that is that if you are shifting through lots of the low-value work rapidly, you can involve your more junior lawyers in more complex work earlier, right? Because there's just less junk work for them to do. That's a huge uplift. That is really, really important. So, I've got trainees and NQs negotiating multi-million-pound deals. Just, you run with this, come to me when you need me, right? And I'll dip in and keep an eye on. But broadly, you can allow them. They've just had much more access to good quality work much earlier in their career, which I'm very happy about.
I think it's one of the best opportunities we've got to actually make people within organisations work together. So very often, I've heard lots of people say that NQs and trainees and people working in our businesses who perhaps don't have the same perceived level of experience don't contribute. Actually, this is one of the best opportunities to get the younger and dynamic individuals in your business to talk to you about their knowledge. And their knowledge will have grown up during their education periods, during their development with these tools. And actually, for those of us that have been in the industry too long, potentially, actually this is a great reinvigoration process, because actually you see ways of doing things differently, and you actually see ways of cutting the corners of the pieces that you can cut the corners on. And actually that makes a firm work better, because that gives value to those individuals that previously may have been overlooked and perceived in a different way.
I was going to say, I'm old enough to remember when there was a bit of a palaver when BlackBerrys went out of fashion and everyone started using a smartphone. I think there's honestly, that the corridors of my law firm there's never been so much angst as when we replaced the BlackBerry. But then, lo and behold, like 2 months later, everyone can write an email on an iPhone or Samsung or whatever it is. And I guess the point I'm trying to make is that there's no substitute for just trying these different tools, using them. You'll probably find out, if you consider yourself to be tech-phobic or you haven't had exposure to it, you'll probably find out that they're easy to use. And if they're not easy to use, it's probably not a good piece of technology, frankly. But there's also really, for senior lawyers, there's really important parts of your training that should be built into the tech. Like, for instance, when to collaborate, what kind of tasks you should automate. Again, a good providers, by and large, automate grunt work or repeatable work, but not like the kind of deep advice that a lot of you would disseminate. And so feeding in your day-to-day practice into the tech, into its development, into how it should be applied to your firm is absolutely foundational, and you should have confidence in sort of sharing your opinion on those matters.
Great, thank you. There's lots more I could get into, but I want to open it up to you. Does anyone have a question for our panel? Thank you.
Thank you. Very interesting debate. I work in insurance, so I'm obviously going to come at this at a certain angle. I'm just wondering, given the assurance that people expect, from the clients expect or are entitled to expect, what can be done with tech companies whose assurance is nowhere near the level of assurance that a law firm gives? So typically a provider that you might be relying on is giving a tiny amount of assurance to the firm, and implicitly the firm is absorbing the risk of that gap between what they can collect if something goes wrong and what their exposure is, which is a huge increase. And I was very struck by your example of using potentially a Magic Circle firm to confirm the advisory that you were getting very cheaply. I think that's quite a difficult task, by the way, but it is their assurance and it is their stock in trade, is that they've got a huge level of indemnity. But do you have minimum standards that you expect from the providers you work for? How do you negotiate those? Do you get anything more than the standard, our liability is limited to our fee?
I've got quite a bullish position on that one, if I may. I think it is ridiculous to assume a technology company should bear the liability, because you're basically saying lawyers who are regulated and the regulator itself has no value. Your job, my job, is to bear the regulatory brunt of my advice. However I get there, whatever tool I use, whatever book I read, it's no different than if I picked up an out-of-date book off a law school library 20 years ago, right? I haven't got the latest edition, crap, right? I've said the wrong thing in court. Now, that really matters. Most tech providers will provide some level of assurance normally for material breach of their contract, some kind of material failure in the product, but that's about how the product functions. That's tech product liability. That's not legal advice liability. You'll struggle to find a legal tech provider that doesn't have quite clear, this is not legal advice. There was a big case called with Rocket Lawyer in the US many years ago, unauthorized practice of law. Every provider has big disclaimers about this kind of thing. But I think that's right. And now if the SRA, and we saw with Garfield AI recently, if there are tech companies, pseudo-tech, pseudo-law firms who want to take on that hybrid liability, great. That's exactly how it should be. Someone wants to present it as a regulated professional to an end user. That's exactly what regulators, not just in law, but in medicine and all the rest, are there to do, is to enforce good practice by people who the public or their customers expect to have a level of quality. People don't expect ChatGPT to provide the same level of quality legal advice to anyone off the street as to a complex M&A transaction worth £1 billion. You go to a specialist provider for a service, and you expect a regulated provider to provide a good quality of care. That's my view.
Unsurprisingly, I agree 100%. I mean, there's
no biases here.
Yeah, there's a lot of entrenched technologies out there. If you're using, I don't know, Workshare Compare and the red line isn't quite right, you're not going to sue Workshare. I mean, you should be checking your work. Ultimately, your client instructs you on the advice that you provide. You can use whatever technology you want as part of that, but it's your advice. So, yeah.
So that's what makes our life really, really difficult. I agree with that. I mean, I don't think there is any disagreement, and I get the insurance question and the reason for the prompt. But actually, this is about us running our businesses properly. This is about us acknowledging that it doesn't matter whether you are running a corner shop, a technology organisation, a law firm, multinational, high street, whatever. It's about having faith and confidence in how you do your job. If you are running the firm, your responsibility is to run it properly, and your obligation is to make money. The only reason, well, hopefully the only reason any of us are in business is to earn a living, pay our mortgages, and have our chosen lifestyle. That's where the risk point comes in, and we bandy around the word risk and profiles and firm-wide risk assessments and all sorts of things. And actually all of them are about saying, how do we ensure that what technology we use, what providers we use for other things outside of technology, contribute a value to the business, enable us to earn more money, and are safe, because the only person that we have to protect is the client. And we have to put them back at centre stage. So our business makes money by looking after clients and them paying for our services. So when we're doing the risk profiling for our business, that is more than looking at our regulatory obligations. It's more than just choosing a provider because we like their product. It's about saying, how does it contribute to our business? Are we happy with that contribution? And are we feeling safe that by choosing them, we aren't going to expose ourselves and our clients to a potential risk in the future? And that's really difficult, massively difficult. I'm not belittling that challenge.
We've got a question at the front here.
Thank you. I'm Maya Ali, and I have a high street medium-sized firm in Coventry, Maya & Co. Solicitors. I have about 25 staff. I brought 2 of my staff here with me. And thank you. Your presentations are, although I did come a bit late, went to the other office. So it's very useful, and thank you. One of the reasons I'm here is that AI is obviously very popular, and I have a lot of young staff in my office. I've got 2 here with me. Now, I've come here today. You can read about a lot of what you're saying. And I said to my staff, let's go and see what the problems are, the real problems, which you faced, which not always published or in a given, we haven't faced yet. So what kind of real problems have you faced that a law firm size of mine that we can face and what we can prevent from us, that can prevent us from facing that. So if you can answer that question, thank you.
I guess running a couple of firms, so my biggest problem is people telling me something that is incorrect, telling me that it's going to solve my problems, telling me that the solution they're providing for me saves the world. And actually then unraveling that. And that includes internally, as I said at the start, we're part of a very, very large Australian organisation. And they gave me a chunk of money and said, yeah, you go and play with AI. And actually they gave me a group of people who were technologists, had never worked in a legal business, and they came in and looked at things that we tried to tell them to look at and came out with conclusions that didn't actually help me because they didn't move the dial as far as the client was concerned. What they were producing was amazing, phenomenal, and I loved it, but it actually made no difference to the client, and therefore it made no difference to my business. It didn't change my profitability, didn't change anything other than speed. Sorry, but that didn't matter. In that particular instance, it didn't make any difference. So I think to answer your question, the problem is about communication, and that is 9 times out of 10 our biggest issue in our industry is communication. And whether that's communicating with other lawyers, whether it's communicating with our clients, each other, it's trying to get your point across and trying to explain to somebody what it is that you actually want to do and solve. And finding the correct vendor and third party to work with doesn't mean it's the best product out there. It just means it's somebody you can communicate with and you can get on with and gives you what you need at a price you can afford.
There's a cash problem, right? So if you are outside of, say, the UK top 50 law firms, there is a limit to the amount that you can basically subscribe for. And so that impacts not only procurement. So if the quantum of the contract is below a certain level, your ability to change the terms is going to be very, very limited. If your contract is below a certain level, your ability to get proper training from real people that work at that company is also going to be somewhat limited. And that is just the way that a business works, because the company would lose money if they dedicated resources to that kind of thing. Now, the way that you navigate that, I think, from the procurement point, and it probably speaks to the first question as well, the way you navigate that is making sure that the company you're contracting with has bulletproof policies. And so do they have proper information security accreditations, ISO 27001, etc.? Are their terms reasonably drafted? Are they English law and so forth? But also the key thing, the way that you can navigate not necessarily getting that one-to-one training, which is so important for adoption, is usability and proper training models probably embedded in the platform. And that is absolutely fundamental. Beyond the additional tricky piece, which is difficult to do at low cost, which is ring-fencing your client data, which without spending tens and tens of thousands of pounds a year is very, very difficult to do using particularly a lot of Gen AI platforms.
I'm not going to offer you an answer to your questions, but what I'd like you is you are welcome to join our legal tech committee. You are based in Coventry, isn't it? So yeah, you are within our catchment area. And now our committees, we have a diverse background of members. We got big firm, small firm, barristers. They all have their unique questions, unique problems. So we create a safe space for people to exchange insights. I say safe space is we never take any detailed minutes in our discussion. But we could learn from each other. Sometimes you may find an answer from your peers. That could be somebody may already have done it before. So that is how we welcome members from different diverse backgrounds, and it could be enrich what we want to do. So yeah, we could have a talk outside these meetings if you want. Yeah.
Great, thank you. We have another question from the floor here. Thank you.
Hiya, I'm Beth. I work at Roythorns, just around the corner, so private practice. Playing devil's advocate a little bit, we've got a lot of the younger generations coming through as trainees and paralegals. Obviously, they're very used to using legal tech, not even just legal tech, but technology in general. One thing I've really noticed, and is probably best placed with you, Alan, being the kind of the educator, the academic, how do you balance using technology and almost hiding behind it and losing those soft skills? For instance, we have trainees and paralegals that can be quite nervous about picking up the phone and having a call with a client and just getting the information very quickly there and then, and you miss out on the intonations that you have with the conversations versus just hiding behind an email and sending an email and waiting for an hour to get a response. How do you balance that?
This is exactly what we want to achieve in my teaching. So we are not teaching students not only to learn legal tech as, first of all, we need to understand as a tool, it's not a turnkey solution. And secondly, as I mentioned, I reiterate the usefulness of having this hackathon learning style. So we promote teamwork, so we develop the skills, soft skills at the same time as we deliver to teach students about what do you mean about the neural networks and things like that. And more importantly is to give them the hand-on experience so that they could think about it, using it critically, and understand the limitation of AI and what they should do in future. So that is how I see it. To balance it, in fact, in the education sector, we have a big challenge. So at the same time, we want to catch up with the industry, tell them to use AI, tell them to use a lot of things during the session. But coming to the assessment, what are we going to assess them? We need to assess them about their knowledge, their real understanding. So there's a big debate at the moment how we assess them. So if you leave them to write 2,000 words dissertation, fairly quickly, they could use, and we have to rely on turn it in. But turn it in, you could play around with it. There's a way that you could limit it to 20%, and if it is under 20%, it say, well, you passed the test. So we need to think about, the how we assess students. Things like, going back to the SRA, the SQE, go back to the multiple choice question, or like the old style LPC, do exam, maybe. But we don't want it, we are still developing and trying to balance it, that's the good words, how to balance it. On one hand, we want to develop their AI skills, we want them to talk about, at least to talk about different AI models and things like that. But at the same time, when we come to give them the grade, whether you are first, 2-1 and things like that, that is a different business that we need to look at.
Yeah.
Could I add something to that as well?
Go ahead.
Because that was about AI, and that makes a lot of sense. But when I heard your question, it was actually, how do I get people to pick up the phone? That's all I really heard, right? And that's a problem, like we can say it's a Gen Z issue, whatever you want, right? But it's the same, so where I lecture at King's in London, my executive education course, but also the more junior one on the LLM, is majority assessed in like what they call the Harvard model, which is class participation. You don't speak in class, you fail, right? You have to talk up. It doesn't matter if I can pick on you and ask you a question. If you haven't volunteered at some point and consistently, you will fail the class. And it's the same, it's a human organizational issue that you discussed there, which is how do we measure success in our employees and how do we drive them towards greater performance? I'm guessing there isn't a KPI for your juniors which says, we want you to actively engage with clients. If you don't pick up the phone to clients at least X amount of times per week, right? Even if it's just to check in on, you don't have to bill them, right? Write it off, but we want you to build social skills. We consider that an essential part of your training. That's going to affect your quarterly performance, whether you get a job here at the end of your training contract, your bonus if they're a junior lawyer, whatever it is. That is one of the KPIs that I have in my team, which is direct client engagement, right? They're always trying to send emails, and I always get them to say, have you got on a call? Lo and behold, lots of problems get solved when you get on a call, right? Sometimes, hey, their office is round the corner. Have you offered to just go meet them, right? That is an active KPI in their quarterly performance.
Yeah. Just a very small thing to add, Matt. I actually wonder whether the problem you raised, as kind of what Harry was alluding to there, is actually a societal problem rather than a tech problem. I think I've experienced that a lot, particularly with colleagues who've gone to university during the pandemic, by way of example, and the subsequent norm to work from home, which I am, by and large, very supportive of in most aspects. However, it's bad for junior lawyers. Working from home 5 days a week is bad for junior lawyers, in my opinion. And this really small thing of, when I was a trainee, when I was a junior, having a partner in my office who was on the phone, listening to the way they spoke to people, encouraging you to do the same, is such a foundational, soft skill that you're just not going to get if you're working from home. And it's kind of up to employers to kind of incentivize face-to-face collaboration, which will hopefully give you the skills to pick up the phone and various other things.
I think it's all about balance, isn't it? And I think that's what we kind of lose. So we do an innovation conference, which is all about tech and all about AI and all about those things. Actually, it's not. Life's about balance. It's whether, we're talking about your 5 a day, your balanced diet, whatever it is. And you're right, we have lost. But also you have a client base who don't want to talk on the telephone because they sit in that same categorization. So it is all about everything being balanced and making sure that we're delivering it in the way that's needed. Doesn't make it wrong that somebody doesn't want to talk on the telephone, but maybe in those particular circumstances it would be better if. And I think it is just keeping that balance.
I actually like saying to my trainees, there is a thing which is, I don't, sort of riffing on that, which is I said, I actually don't care if it's the right thing to do or not. I still want you to do it because I think it might not be the perfect thing to do in this circumstance, at least ask the question. Because I want you to force that experience, because you'll never get, because especially if you've got a shyer employee who's the kind of person who won't ask the question, sometimes it's the being in person in the office, the gentle nudge that you get with that is helpful.
And you learn anyway, yeah. So we are going to have to wrap up, but I just wanted to check whether there was any question that someone didn't have a chance to ask. Is there one there?
Hi, my question was just in relation to usage and adoption. I think currently in the market there's a plethora of really great legal tech solutions, but one thing you typically tend to see is law firms or in-house counsels might sign up for an enterprise solution, but when it actually comes to usage and adoption, where you're kind of challenging how people have maybe done things for the last 10 or 15 years, that typically tends to be a big problem. So a question for all of the panel, how have you found in your experiences when it comes to that usage and adoption element of getting teams basically on board for the long run?
Yeah. Should we go quickly through, just a short answer each?
Our data is clear. In-house teams adopt and use much faster. Law firms are slower to change, basically.
Yeah, it's always, adoption is always good. We developed a student from very beginning is to understand the background of the technology and how to adopt them and look through. We always also have this kind of matrix, so we could have a checklist for people to adopt it. Yeah.
Yeah, for me, if it's a nice-to-have tech, it's no or slow adoption. If it's actually addressing a business need, failing ideally pinned to revenue, then adoption tends to be pretty good.
Yeah, herding cats. Try and get some early adopters in the business. Try and make sure that you've got some that are buying into it and get it, and then put them out there into the environment and try and get them to do your job for you.
Thank you very much to all of our panellists, who I think were great. In this moment, could you just join me in saying thank you very much to our panellists? Thank you.